the StudioCF, a video law blog of the Carlton Fields law firm. My name is Ellen Lyons. I'm a shareholder and business litigator at the firm. Joining me is Joanna Garcia, also a shareholder and business litigator at the firm. The topic of this episode is arbitration waiver in the context of litigation. Joanna, put this issue in context for us, please. When does this issue come up?
Let's say, for example, a plaintiff initiates a lawsuit in a circuit court in Florida, and that lawsuit relates to a contract that contains an arbitration provision. Typically, what you'll see is that the defendant that wants to assert its right to arbitration under that contract will respond to the initial complaint with a motion to compel arbitration. In other instances, however, the defendant may take other actions other than filing a motion to compel arbitration, and we'll be exploring whether some of those other actions could result in waiver of that defendant's arbitration right.
So what do Florida courts consider when ruling on motions to compel arbitration?
The requirements under both the Federal Arbitration Act and the Florida Arbitration Code are threefold. First, there must be a valid written agreement to arbitrate. Second, there must be an arbitrable issue. And third, the party that's seeking to compel arbitration must not have waived that right to arbitrate. So here, we're going to assume that we have a valid agreement to arbitrate and that we have an arbitrable issue. So what we have to consider is whether the actions that the defendant has taken after the initial filing of the lawsuit will result in the waiver of its right to arbitrate.
How soon after a lawsuit is filed do the defendant's actions matter for purposes of waiver?
Well, actually, any action that's taken by a defendant immediately after the lawsuit is filed could be considered by courts if it would shed light on the defendant's intent to invoke arbitration. And the Florida Supreme Court has said that courts must look to the totality of the circumstances of each particular case in order to make a finding of waiver.
What specific types of conduct have Florida courts found to result in waiver of arbitration?
Well, one example would be if the defendant, in response to the plaintiff's initial complaint, files an answer to that complaint without asserting or demanding a right to arbitration therein. Not doing so has been held to be a direct attack on the merits of the plaintiff's complaint. On the other hand, if the defendant files an answer, but in the answer asserts affirmative defenses that raise the right to arbitrate, courts have held that in such an instance, waiver has not occurred. And it's actually important to note also that some Florida district courts actually require a finding of prejudice to the non-moving party in order to make a finding of waiver.
Are there any other types of filings that may result in waiver?
Some other examples where Florida courts have found waiver are the filing of a motion to dismiss or motion for summary judgment, for example, in response to the plaintiff's complaint without asserting or demanding a right to arbitration. Also, the filing of a cross-claim or a third-party complaint have been held sufficient to establish waiver in those situations as well.
What about engaging in discovery? Will that result in waiver?
It really depends when it comes to discovery because, as I said earlier, courts have to look to the totality of the circumstances of each case. But one Florida court, for example, found that in a situation where the defendant filed an answer in response to the plaintiff's initial complaint and proceeded with discovery in the normal course of that litigation, but 2 months later discovered that there was an arbitration provision in a contract that was at issue in the litigation and promptly filed a motion to compel arbitration, the court found that no waiver had been established in that situation. Another court, for example, has held that just serving written discovery is not sufficient to constitute waiver.
Have any courts said the opposite?
Yes, actually, some courts have held that a party's participation in discovery that's related to the merits of the claims at issue could result in waiver. So one example might be if a defendant takes the deposition of the plaintiff. That could result in waiver if it explores the merits of the particular claims at issue in the case.
What if a defendant timely asserts the right to arbitrate at the outset of the litigation? Can a defendant later waive the right to arbitrate?
Yes, actually, even if a party timely files a motion to compel arbitration, it can still waive the right to arbitration based on subsequent actions taken. So, for example, conducting extensive discovery after the motion has been filed, scheduling depositions and the like, that could be sufficient for finding of waiver even after they have filed a motion to compel arbitration.
Finally, Joanna, what tips would you suggest for preserving the right to arbitration?
Well, as you know, no two cases are generally alike, so each case must be analyzed on its own merits. But if a contract exists, a review should be undertaken to determine if there is an arbitration provision in that contract and whether it would be the best strategy and option for the client to invoke that provision to arbitrate. And of course, attorneys should always consult the relevant statutes, codes, and case law to determine the most appropriate time, manner, and procedure to raise the arbitration issue.
That ends this episode of StudioCF. We hope that you found this discussion informative. Please take a moment to browse our other legal topics and check back each month for new episodes. Thank you for watching.